Hello, everyone. It's just about 11 o'clock, so I think we can go ahead and get started. Welcome to our third Tuesday webinar. The topic today is how to handle complex ADA accommodations and avoid costly litigation in the new year. It's always a good time at the beginning of the year to check in with your business processes, check in how you're handling things, such as reasonable accommodations for disabilities, employees you may be already accommodating, your policies and procedures for dealing with requests for accommodation that might come up. So it's a good time to check in with the ADA at the beginning of the new year. I'm Britt Waterman. I'm the senior attorney at my HR counsel. And today we are going to talk about ADA compliance and accommodations. So we'll talk a little bit about the law, some definitions, what we need to do to comply with the law, and a little bit about the consequences of being out of compliance, not complying with the law. Some housekeeping, and it looks like it's not on my slide there, but just some housekeeping items. The presentation will be recorded and it will be sent out to all attendees. So you'll receive a recording of the presentation. You'll also receive a copy of the slide deck to reference along with the recording. Everyone who attends the full presentation will receive an hour of HRCI recertification credit. The code for that will be in the follow-up email that you receive after the presentation. We'll also be sending out a survey with that follow-up email. Please complete it. It lets us know what you like, what we're doing, what you might like to see us do in 2021, topics you'd like us to cover. And you'll also be receiving our guide to the interactive process, which is a guide that will help you through the steps that you take when you have an employee who may need an accommodation under the ADA. So you'll be receiving all that in a follow-up email after the presentation. So what is the ADA, the Americans with Disabilities Act? Well, the Americans with Disabilities Act is a federal law. It was passed back in 1990. The law was intended to address the needs of people with disabilities by prohibiting discrimination, not just in employment, but also public services, public accommodation, telecommunications. So things like allowing a service dog in a department store, so something like that would be covered by the ADA under public accommodations. Telecommunications, making websites accessible to people who are visually impaired. There are other legislation that addresses that, but that's kind of springboarded from the ADA. So things, anything that that helps people with disabilities, addresses their needs, and allows them to take advantage of all of the services and accommodations that are accessible by everyone. The ADA applies to employers with 15 or more employees, and that's federal law. So that's the ADA is a federal law, and that applies to employers with 15 or more employees. However, if you're thinking, well, we don't have 15 employees, we can just check out here. State laws apply to smaller companies. So there are state equivalents of the ADA that apply to smaller companies and have different definitions of disability. So your state most likely has an anti-discrimination law or a human rights law, a fair employment in law or a fair employment in housing law that will apply to a company with fewer than 15 employees. The Minnesota Human Rights Act here in Minnesota applies to companies with more than one employee. The Connecticut Fair Employment Practices Act applies to companies with 3 or more employees. So those state laws apply to employers with far fewer employees. They really narrow it down. So even if you're not covered by the ADA, the chances are good that you're covered by a state equivalent that is also going to prohibit discrimination against someone on the basis of disability, and is also going to require you to provide a reasonable accommodation to allow that person to participate fully in employment. So the Connecticut Fair Employment Practices Act, for example, it protects this, specifically the law protects individuals with mental disabilities, intellectual disabilities, learning disabilities, physical disabilities, including not limited to blindness. That's spelled out in their law. Other laws are not as detailed. They use disability, and you would look to the definition of disability in the federal law, the ADA, to define disability when you're looking at one of those state laws. So what is the definition of disability? Well, disabled means, and this is under the federal law under the ADA, disabled means an individual with an impairment that substantially limits a major life activity or a record of a past history of a substantially limiting impairment. Under the ADA Amendments Act of 2008, which was the ADA-AA, that was a law that was passed in 2008 that really expanded the ADA. I think there was some ambiguity about the ADA and what was really a disability, what was a major life activity. Is the definition too narrow? Is it too broad? Are we leaving people out? And there was a lot of ambiguity, and people not knowing who they had to accommodate. So they passed the ADA-AA in 2008, and that act said that the definition of disability shall be construed in favor of broad coverage and should not demand extensive analysis. So that really opened up the definition of disability to a broader interpretation, and opens it up beyond what we would normally think of as a very open and obvious physical disability, such as someone who is blind or someone who is, very obviously mobility impaired, to people with more invisible disabilities, maybe a chronic illness that affects the respiratory system or the digestive system. So to back up, major life activity. So what does it mean to substantially limit a major life activity? A major life activity can mean many different things. So a major life activity can be physical activity, and that includes, like I said, walking, if someone is mobility impaired, seeing, hearing, standing, sitting, lifting, performing manual tasks. Those are some of the more open and obvious limits to a major life activity that we would think of when we would think of accommodating someone with a disability. But major life activity can also mean a cognitive activity. So learning, reading, thinking, communicating, which opens the definition up to a number of mental health disabilities. Something like ADHD would be something that would limit a major life activity, such as thinking or concentrating, for example. Major life activity can be bodily functions. So like I said, the respiratory system, the digestive system, the reproductive system, or the neurological system. And so that would be somewhere where you might get into a less visible disability, where someone may have a chronic illness that would not be open and obvious to you when they began their employment, or it might arise at some point during their employment. And that's something that you may have to kind of gather clues on if someone is asking for time off from work and things like that for an illness that you would look into as an accommodation. It would be a little more nuanced than someone who, you know, begins the job and is using a mobility aid such as a wheelchair, and you know you need to install a ramp to the front door. So the definition of disability is much easier to meet now than it used to be. And in employment, the definition of disability, a disabled individual can be an applicant or an employee. So both applicants and employees are entitled to reasonable accommodations. They're both covered under the ADA. And so you need to look at, you know, accommodating an applicant, such as if you have an applicant who is hearing impaired, accommodating that applicant throughout the interview process to be able to communicate with that applicant would be an example of how you would accommodate an applicant with a disability, for example. So the definition of disability under the ADA in the case of employment, it applies to a qualified individual. Now, a qualified individual is someone who, with or without a reasonable accommodation, can perform the essential functions of a position. If there is no way with any accommodation that a person can perform the essential functions of the job, they're not a qualified individual. You don't have to accommodate someone when the accommodation would be futile. If there's no way to accommodate someone because they're unable to perform the essential functions of the job, even with an accommodation, they're not a qualified individual. Most people are going to be qualified individuals because most individuals, there's going to be a way that you can modify the marginal duties of the position or provide some other type of accommodation that is going to allow them to perform the essential functions of a position. You're generally not going to get someone applying to a position that there is no way that they could possibly perform that position. That's probably going to sort itself out through the application process. It's a good reason to have a good descriptive job description when you're posting job descriptions for hiring, to be very clear about what the physical and maybe mental requirements of the job are to kind of encourage that self-selection during the application process, rather than getting to a stage where you're trying to determine, you know, is this person a qualified individual? If you're very clear in your job description, that's going to help your applicants, and it's going to help you through the hiring process. And I just want to touch on in the definition of disabled, the record of or a past history of a substantially limiting impairment. Now, what that means is, and under the ADA, which is, you know, prohibiting discrimination against someone with a disability and requiring you to accommodate someone with a disability, a record or a past history could be someone who, for example, had cancer and is now in remission from cancer. They have a past history of a disability. They're in remission. They don't currently have cancer. If they have to take time off to go have a follow-up appointment, to go have a scan to make sure that the cancer hasn't come back, a reasonable accommodation would be to give that person time off for those appointments. So that person would qualify as a disabled individual. And of course, you also, you know, you couldn't discriminate based on the record of the past history. You couldn't refuse to hire someone or not place someone in a position because you think, well, you know, in the past they've had, you know, issues with this type of injury or this type of illness, and we're afraid that it might happen again, so we don't want to place them in this position. You can't consider a record of a past history that would be discriminatory. So keep in mind that even if the disability is not currently active, it is still considered a disability, and you do have to follow the law in treating that person as an individual with a disability. And so once you're aware that that you have an employee who has a disability or a medical condition that may be affecting their ability to perform the essential functions of their job, you have a duty to engage in the interactive process. Now, what triggers the interactive process? The interactive process is triggered when the employee asks for accommodation. So when an employee comes to you and says, I need modifications to my workspace, I need to be able to bring my service dog to work, I need to take 2 weeks off for medical treatment. When an employee asks for something clearly. The interactive process is also triggered when the employer knows that the employee has a disability or knows that the employee is experiencing work-related problems because of the disability. And this could be something, like I said, where there are multiple absences due to illness, due to an illness that appears to be chronic. I'm not talking about, well, she had the flu last week and this week she has a cold. This is something where an employee is having perhaps some attendance issues that are coming to your attention because of recurring doctor's appointments or something such as migraine headaches, maybe a disability, and an employee is having some time away from work because of that. And this would apply, people in larger employers may be aware of an employee may be entitled to FMLA, may be entitled to intermittent leave, and you may think, well, that intermittent leave or that time away from work doesn't apply because we don't have enough employees to qualify for FMLA. That intermittent leave from work or time off from work can also be a reasonable accommodation under the ADA. So if you have an employee who does need time off for appointments or something of that nature because of a disability, that would be a reasonable accommodation that you would provide for that employee. So that's when you would have a duty to engage in the interactive process. So what is the interactive process specifically? Well, the interactive process is a discussion between you as the employer and the employee regarding the employee's work limitations due to their disability and what, if any, reasonable accommodations that you as the employer might have to provide. So it's an open back and forth dialogue between you and the employee. You're sharing information. It's right in the name. It's interactive. It's open. Both parties are participating. Both parties have a duty to cooperate in the process and to provide information in good faith. If one party shuts down and abandons the interactive process, then the interactive process ends. There's either the employer has failed to comply with the law, or if the employee has abandoned the interactive process and is no longer participating, then the employee may no longer be entitled to an accommodation. But that would be after many attempts to engage the employee. So the employer's steps in the interactive process: first, determine the essential functions of the employee's job. And like I said, this is something that should start way before hiring. This is something that should start at the job description phase. Before you ever even post the job for hire, you should determine what the essential functions of the job are, what has to be done, what can't be assigned to someone else. I mean, what is a marginal task? What is something that another employee in the department could take over? That's not an essential function of the job. What is it that the employee needs to do as part of their job? And attendance can be an essential function of the job. If you've got someone who's working as a security guard and they're the only person at their post and there's no one around for miles, I mean, attendance would be an essential function of that job. There's no one to cover when they're not there. I mean, but you would include that in the job description. Of course, we want good attendance for all of our employees. However, different jobs are different. There are, many jobs where the environment can function if an employee is absent for a day. In that case, that would not be an essential function of the job, even though the expectation, of course, is that your employees have good attendance. So you would determine the essential functions of the job. You would put them in the job description, so you have that job description set and ready to go. The next step would be to establish the individual's limitations. So that would involve unless the disability is known and obvious, for example, someone who is blind, someone who has an obvious mobility impairment, in those cases, the disability is known and obvious. You don't need to request more, and you shouldn't request more medical information in that case. If someone has been discharged from the hospital and comes to you with a discharge summary from the hospital that outlines exactly what their limitations are, what they can and can't do, you cannot request more information. Once you have an idea of what their limitations are, you can't push for more. But if you don't know what the limitations are, you can send a questionnaire with the copy of the employee's job description and have the employee take that to their healthcare provider and fill out the questionnaire, and have the employee bring it back and say, okay, well, they've seen your job description, they know what you can or can't do, and now let's take a look at this and let's discuss. At that point, you would explore potential accommodations with the employee. And this is where it's very important for it to be a back and forth dialogue, because both the employer and the employee are going to bring different ideas to the table. And this is a chance to really get creative and to think about, well, what's going to work? The employee may have ideas that you would never even think of that may be a reasonable accommodation that's going to work really well in your environment. You do not have to give the employee their first choice of accommodations, as long as you provide an accommodation that is reasonable. If you have a list of accommodations that are reasonable, the employee does not get to choose from that list. If you've got multiple options that are reasonable, you can choose the one that you would like to provide. So you would select the accommodation that is most reasonable, that is going to allow the employee to perform the essential functions of their job and make things go smoothly. So reasonable accommodation, assistance or changes to a position that will enable an employee to do his or her job despite having a disability. Again, this could be, voice to text software for someone who is blind or visually impaired, for example, or change to work equipment, some sort of ergonomic adjustment that would allow an employee to do their job. Other examples, modifying the job to remove marginal functions. Now, this is not primary functions that you're removing. This is marginal functions. This is if you can look at a work group and you can rearrange responsibilities among your workers and say, okay, we can take this off your plate, we can take this off your plate, and this will allow you to perform the essential functions of your job if we take these duties and reassign them. That would be an example of a reasonable accommodation. Reassignment to another equal position, an equivalent position. Reassignment is really the accommodation of last resort. You want to try and come up with an accommodation that keeps the employee in his or her job before you reassign to another position. And for reasonable accommodation, you're not required to promote the employee or bump another employee from his or her job or create a new job. Those aren't things that would be required of you to accommodate an employee. Now, you do not have to provide an accommodation if providing an accommodation would be an undue hardship. An undue hardship is a very high bar to clear. This is not just, employee morale. Well, reassigning some of her job duties to other employees is going to make the other employees resentful. That's not an undue hardship. Undue hardship has been defined as significant difficulty or expense. This is meaning this is affecting the bottom line of your business to provide this accommodation. This is or is changing the nature of your business. Obviously, if you're a seafood restaurant and you've got an employee with a seafood allergy, you can't accommodate their seafood allergy by removing all seafood from the menu. That's changing the nature of your business. That's not a reasonable accommodation. So something that's going to change the nature of your business or hurt the bottom line of your business, that would be an undue hardship. And if you think that providing an accommodation is going to be an undue hardship, what we recommend doing is doing a written undue hardship analysis, where you really think of all the accommodations you could provide, analyze each one in writing. Why would it be an undue hardship? What would be the consequences of providing that accommodation? And really write out each one and do an individualized assessment. So you've got that documentation. If the employee does decide to pursue legal action, a failure to accommodate claim, you've got that documentation where you can say, we determined it would be an undue hardship, and here's how we determined that. We didn't just stonewall the employee. We actually thought about it. We did the math, we figured it out, and here's our analysis. So that's, you should do a written undue hardship analysis if it comes to that point and you feel that you cannot provide an accommodation. Like I said, some factors for undue hardship: the ability to serve your clients in a timely manner, considering the size of your company. Obviously, that's going to be a bigger impact on smaller companies. If an employee has a disability that's causing them to not be able to meet performance standards, obviously, if the quota is 500 widgets a day and your employee is only able to make 5, allowing them to make 5 is not a reasonable accommodation. That's not going to serve your clients in a timely manner if you're a small company. The nature and the cost of the accommodation needed, again, you've got to see an impact on the bottom line of your business. I mean, refitting an employee's workstation due to a mobility impairment, it's not going to be inexpensive. It is going to be something that may be, a significant expense, or making an area of the premises more accessible. It could be significantly expensive. However, it would have to be truly burdensome. I mean, it's a high bar to clear. So you would have to consider your overall financial resources, the size of your business, the number of employees you have, the type and location of your facilities. These are all factors you should be considering when you're doing that individualized written analysis if you feel that providing an accommodation would be an undue hardship. Leave from work. As I said, even if you are too small to be covered by FMLA or similar state laws, leave from work is often a reasonable accommodation. ADA leave is often a reasonable accommodation for an individual with a disability. Leave could be used to attend medical appointments, get medical treatment, recover from an illness, or as I said, episodic manifestations of a disability. Migraines would be an example, or any asthma would be an example if someone has an asthma attack and needs medical attention. Leave from work to receive disability-related training. If someone gets a service animal and needs to take leave to train with the service animal, that would be something that would be an accommodation. To make repairs to equipment or devices, they need to get their accessible vehicle repaired. You would allow absences from work for that. That would be an accommodation. You must allow an employee with a disability to use their accrued paid leave, their PTO or vacation or sick time, and also obtain additional unpaid leave for reasons related to the disability, again, unless doing so would result in undue hardship. And let me just go back to that. Undue hardship as far as leave goes, this is something that different courts across the country have issued different opinions on what is reasonable as far as leave. And we don't have a clear number, unfortunately, as there's no magic number as in this number of days or this number of weeks or this number of months is reasonable, and anything after that is cut off and is not reasonable and we don't have to provide it. We just don't have that. It's going to depend on the nature of the disability. It's going to depend on whether or not they're able to return to work. If someone is injured or becomes ill and you ask for that information from the doctor and the doctor says they need indefinite leave and we don't know if they'll ever be able to return to work. Indefinite leave from work with no answer as to whether or not they'll ever be able to return, that indefinite leave is not going to be reasonable. Leave if with a return to work date, that's something that you're going to have to consider on a case-by-case basis as to whether that amount of leave is reasonable. A lot of times, a lot of courts will say, even if you're not covered by the FMLA, 12 weeks of leave, of ADA leave is reasonable, because if you were covered by the FMLA, you would be required to provide that in that case. So some courts have said 12 weeks of ADA leave is reasonable. Again, it's really going to depend on a case-by-case basis. It's going to depend on their position and their function within your organization, the size of your organization, what their projected return to work date is, all of that. So it's so there is no magic number with leave. There is no magic cutoff date. It's just really going to depend on the nature of the disability and you know, factors related to your organization, and it's going to be on a case-by-case basis. Penalties for violation. This is the scary stuff. So penalties can be non-monetary, which is hiring, reinstatement, promotion, reasonable accommodation. If you don't hire somebody or you don't accommodate them in the interview and they file suit, you may be required to go back and do so. If you terminate an employee because you say there's no reasonable accommodation, you may be required to reinstate that employee. You may be required to provide an accommodation that you initially decided not to provide. Monetary, back pay, front pay, restored benefits, attorney's fees, court costs, civil penalties, compensatory damages, punitive damages. paying out-of-pocket costs of the plaintiff. So the costs related to being out of work, paying for an attorney, paying for their expenses incurred in a job search, looking for a new job after they were terminated or had to quit because they weren't accommodated, their medical expenses. There can be damages for mental anguish, inconvenience, loss of enjoyment of life, the emotional trauma of being let go from work or not given an accommodation. We don't make this up. These are actual court cases, actual damages that can be awarded to your employees, applicants, or former employees on a failure to accommodate claim. There are also civil penalties that can be very steep. $55,000 for a first violation if you under federal law, $110,000 for each subsequent violation. That's a federal penalty. That's a federal fine by the federal government. And then plus the compensatory and punitive damages of that applicant, employee, or former employee suing you in court. Accommodating mental illness. This is, as I said, psychiatric diagnoses, ADHD, bipolar disorder, depression, many others. A disability is a physical or mental impairment that substantially limits major life activities. So as I said, thinking, concentrating, reading, learning, these can all be limited by mental health conditions. So when a job applicant or employee has a mental health condition that meets this criteria, they have workplace rights under the ADA. When you have an employee who has an anxiety disorder and they have anxiety attacks, panic attacks, they need to take medication, they're unable to leave the house during a panic attack, something like that, that's limiting a major life activity, that's limiting their ability to leave the house, to function. And that's, so that's, they have rights under the ADA in that case. And other examples would be someone with ADHD may need a quieter workspace. Someone with depression may need time off to go through an outpatient treatment program. These are just some examples. Another example of an accommodation for a mental health condition has been, that I've seen in the past, has been working with a different style of supervisor, that has a different communication style. If the psychiatric diagnosis, the mental health condition, affects that employee's, the major life activity of communication, sometimes they may need the accommodation of interacting with someone with a different communication or relational style in order to be successful. And so here are, as I said, the examples of accommodation: more frequent reminders of tasks, due dates, quieter work environment, more frequent short breaks. Some work from home can be an option without undue hardship, of course, and with the realization that there are many jobs that can't be done from home, although certainly now with COVID, there are many jobs that we are adapting to at-home work. So that can be a good accommodation for an employee with a mental health disability. Managing treatment and medication, again, allowing time off for those appointments and allowing time off for treatment. If they need breaks for their medication, if they need a water bottle, if they need juice or food, snacks, they need to eat at certain times. They need to take medication at certain times. They need a part-time schedule or to take time off, reduced schedule. If they have a change in medication, and they're trying to get stabilized on a new medication, that would be where leave would be an accommodation. Anxiety, as we've discussed, working remotely, working from home, and change in the management style of the supervisor would be an example. Employee drug addiction. Alcoholism and drug addiction are both disabilities under the ADA. They are treated differently. An alcoholic is generally a person with a disability under the ADA, whereas someone who is addicted to drugs is protected under the ADA only if he or she is currently not using illegal drugs. Someone who is a drug addict is basically protected by the ADA when they are in recovery. A recovering addict would be protected under the ADA. According to the EEOC, the persons addicted to drugs but who are no longer using drugs illegally and are receiving treatment for drug addiction or have been rehabilitated successfully are protected by the ADA from discrimination on the basis of past drug addiction. So this is something where if it comes to light that you have an employee who has used drugs in the past and they are now in recovery, that's not something that could be the basis of a termination just because you find out that they have a history of drug addiction. That's something that's protected under the ADA. However, current drug use is not protected if you have a drug test that comes back positive and the employee says, well, I'm a recovering drug addict. The use of the illegal drug qualifies as current illegal drug use, and that current illegal drug use bars that employee from ADA protection. So if you've got an employee who is a recovering drug addict, they relapse, they fail a drug test, you can terminate them for that failed drug test. You do not have to accommodate their present use of illegal drugs. Their current use of illegal drugs does not entitle them to ADA protection. Alcohol is a little different. From the EEOC, a person who currently uses alcohol is not automatically denied protection simply because of the alcohol use. An alcoholic has a disability and may be entitled to consideration of accommodation if he or she is qualified to perform the essential functions of the job. However, you may discipline, discharge, or deny employment to an alcoholic whose use of alcohol adversely affects job performance or conduct to the extent that he or she is not qualified. You can't discriminate against someone on the basis of they are an alcoholic if someone comes to you and says, I'm an alcoholic, I've been drinking for months, I need time off to go to treatment. They are protected under the ADA. Time off to go to treatment is a reasonable accommodation. If someone shows up drunk to work and punches another employee in the face, that conduct of punching another employee in the face is not protected under the ADA. You can still terminate for the conduct of violating your policy against workplace violence. But it is something to think about if you have an employee who is having performance issues and you find out that employee does tell you, I'm an alcoholic, I was sober, I relapsed, I've been drinking, that's why my performance is suffering, giving that employee time off to try and get sober, or giving that employee time to try and get their alcohol use under control is something that you're going to want to do. You're not going to want to terminate just based on the performance right away, would be my advice. Like I said, if it's a conduct violation, someone operates a forklift under the influence of alcohol, that's a policy violation. They can be disciplined or terminated in accordance with your policy. But if it's, some absences or some performance and they come to you and say, I'm an alcoholic and I slipped, I, need to go to AA, I need to go to treatment, I need to get this together, accommodating them, giving them a chance to get that together would be the wiser option in that case. However, I mean, you can hold them to the performance standards of their job. Someone cannot come to you and say, I'm an alcoholic, I am often hungover, and therefore I can only produce 50% of what everybody else produces. That's not an accommodation. You still can hold them to the performance standards, but I would say on a first offense for performance or attendance, when it's an alcohol issue and they are trying to get treatment, I would grant that accommodation for treatment. If they are under the influence in the workplace, then I would deal with that as your policy prescribes that you do. Accommodating employees for long periods of time, we touched on this. The ADA is silent as to how much time of unpaid job protected leave is reasonable. It's not meant to substitute for the FMLA or state equivalent. You have to look at what's reasonable under the circumstances. Like I said, the courts are all over on this. Some will say, you provided, maybe you've got an employee who's doesn't meet the eligibility for FMLA, but you as an employer are covered by the FMLA. It may be reasonable to treat that employee as if they were eligible. Maybe they didn't meet the hours of service requirement. It may be reasonable to treat them as though they were eligible and give them 12 weeks of leave. It's all going to depend on the circumstances, the nature of your business, the nature of their position, what their projected return to work looks like. It's all going to be decided on a case-by-case basis. There's no cut and dried answer. Disciplining an employee who is being accommodated. Employees with disabilities must meet the same production standards, quantitative or qualitative, as non-disabled employees in the same position. The EOC suggests giving clear notice of the standards to all employees. You do not have to lower production standards. I think we talked about this. I think when I said if the quota is 500 widgets a day, you don't have to allow someone to only make 5 as a reasonable accommodation. However, lowering production standards in terms of eliminating or reassigning some marginal job duties to assist the employee in meeting their production standards or meeting performance goals, something like that may be required as a reasonable accommodation. And the EEOC guidance also confirms that under the ADA, employees with disabilities must meet the same conduct standards. If an employee with a disability causes the violation of a conduct rule, the employer may still discipline the employee if the conduct rule is job related and consistent with business necessity, provided that it holds employees to the same standard. Again, this is if you have a point-based attendance policy and you've got an employee who has a disability and needs time off for appointments, you're not going to want to assign points for those time off for appointments. You do have the right to hold those employees to the same conduct standards. However, the accommodation is allowing those absences. So, but as I said, someone comes to work and you've got an employee with a mental health condition. You certainly can't discriminate against that employee because of your perceptions of what that mental health condition might look like. You have to give that employee time off. If they need treatment in a psychiatric facility, you cannot discriminate based on the stigma of that or what that might mean to you. However, if that employee violates a conduct rule, you can handle that as your policy sees fit, provided that you're enforcing that policy the same with all employees, disabled and non-disabled employees alike. You've got to be consistent. If you enforce a policy against an employee who's being accommodated more harshly than an employee who's not being accommodated, that's not going to look good, and that's going to lead to some of the penalties that we discussed previously. So remember, compliance is not optional. You can find more resources at myhrcouncil.com. We're always available. You can also email us at info@myhrcouncil.com with any questions about the ADA or other HR and employment law issues. As I said, there will be a follow-up email with all of this information that was provided in today's webinar. So thank you very much for participating today, and I hope you all enjoy the rest of your day.